15th of August, the President of Malawi, Dr. Lazarus Makathi Chakwera, witnessed the signing of the memorandum between Malawi Law Society and Arbitration Foundation of Southern Africa under the Ministry of Justice. And we have also seen on the 5th and 6th September this year, 2024, the Malawi Law Society and Malawi Chamber of Commerce and Industry engaging the business community here in Malawi. What does this mean economically, and what does this mean to the justice system of Malawi? To talk more on this, I have Mr. Patrick Mpaka. My name is Ghwabupi Mwabungulu, and this is Unpacked on MBC. Welcome to the program, Mr. Mpaka.
Thank you very much, Ghwabupi, and thank you to the audience for giving us the time to discuss the Malawi International Arbitration Center.
Thank you so much. What is arbitration, and what necessitated it, and this whole idea of MAIC?
Okay, so in 2021, the Malawi government signed up a convention. It is called the New York Convention of 1958. That convention is an international convention whereby countries, currently I think it has 172 signatories. Malawi was, in 2021, Malawi was the 167th country to sign the New York Convention. So if a country is a party to a New York Convention, investors can come in that country, and if they have an agreement to resolve their differences by arbitration, then it means that the arbitration award that is made in that country is recognized across the 172 countries that are signatory to the convention. So, for example, an investor, let's say from England, when they want to invest in Malawi, they'll be looking at, okay, in this country, I know there are laws. If I have a dispute, if I want to invest in this country, if I have a dispute in that country, are they a party to the New York Convention? Will I be able to enforce my judgment? Am I going to get the benefits of using arbitration as opposed to the cost? Because everyone knows, in commerce, everyone knows that the costs are usually all over the world. They are always crowded. So this is the only space that the law has allowed the private sector to say, if you agree that you resolve your differences by arbitration, we will allow you to go there. We will not intervene. So by signing the New York Convention in 2021, Malawi already signaled to the world that it wants to join the international community of countries that are parties to the convention and can resolve their investors can resolve differences by arbitration. So what we did, the Malawi Law Society, following that event, then we started working with our colleagues in South Africa, working with our colleagues within the SADC region, to try and bring that legal framework into life. So you saw that in 2022, on 15th of August, you've talked about it. We invited the state president, the Minister of Justice, the Chief Justice, and to sign a memorandum of understanding where we were trying to set up the legal framework. So in 2022, 2021, 2022, 2023, we, from the Law Society, working with our colleagues within the SADC region, we were setting up the legal framework for international arbitration in Malawi to complement the local, domestic arbitration. So we've done that, and then now we are at a place where we can begin to set up the investment center, the arbitration center on the ground.
Now, since we have mentioned the team players, that has been from the Chief Justice himself, and then the President, and Mr. Mvalo himself getting involved. Now, is this the first arbitration regime in Malawi? And if it's not, what has changed? What are the additions, and what's the way forward?
It's not the first arbitration regime in Malawi. For domestic arbitration, that is arbitration concerning local business, we already have the Arbitration Act of 1967, which has been regulating arbitration. But for international arbitration, which involves now, for example, a business which has investment here in Malawi, in Zambia, in South Africa, the laws are different. So what the international arbitration does is to make the law kind of uniform. So it's the first time that we have had that law. It was passed in Parliament in December. It was signed by the President in January. So the difference is that so in international arbitration you are dealing with the international investors between countries, even what we call interstate arbitration or investor-state arbitration. So this legal framework introduces that in Malawi.
Mm-hmm. Yeah. Now, since the legal framework is introducing that in Malawi, now we understand Malawi enacted the International Arbitration Act. What's the significance of this law? So
the International Arbitration Act that was passed in Malawi, actually, as I said, as I was saying, when we started engaging government, we needed to finish the legal framework for international arbitration. So the significance of that law is that now it localizes the international law on arbitration. It makes it part of the law in Malawi, so that any investor from across the world, when they look at Malawi, they'll be asking themselves, if I go and invest in this country, and I have a dispute, will it be resolved according to the world-renowned standards in the 172 countries that have set the standard for resolving commercial and investment disputes? So they will tick that box, because now we have the International Arbitration Act as part of the law in Malawi. What the International Arbitration Act does is to adopt the New York Convention and the model law that is used across the 172 countries that are parties to the convention. Mm-hmm. So by passing the law, which basically adopts the New York Convention, Malawi has joined a world of 172 countries that are saying, if you invest in our country, we are going to follow the international standards for managing investments according to the law and practice of international arbitration.
Since Malawi has joined the big league, the international league,
yes.
What would be the relationship between the laws of Malawi to be engaged as a local regime?
So for the local regime, we already have the Arbitration Act 1967, but also I know that at the moment the government is working. We have asked the government to say, can you also update this law so that it now meets this standard, because we are using a 1967 law. So it will be complementary. I think, to answer your question directly, these will be complementary. Actually, it is better that we have also a robust domestic arbitration framework, because most of the arbitration actually will be the local one. The international ones come once in a while, and they're involving big transactions. So it is important that the local framework is also up to date, and I know that the Attorney General is working on that. He made that indication at the conference that we had last 2 weeks.
Mm-hmm. So, as we know that arbitrators are chosen by the parties.
Yes.
What's the cost implication by having a matter dealt with by an arbitrator as opposed to the courts?
Arbitration is not really cheap. This, I must say, is quite expensive. But the background is that business people want efficient movement on their disputes. So it's in business, you are bound to have differences, but you also must continue the business relationship. So the advantage of arbitration is that the parties have the control. They can choose who should resolve their disputes. That's also how the efficiency comes, because if it's a big construction contract involving, let's say you're dealing with a railway line, there'll be engineers involved. Usually you are able to choose the arbitrators that might include an engineer. But if you go to court, you still have to deal with a judge who perhaps is just a lawyer. Okay? So arbitration is not limited to the lawyers. You can have arbitrators from all across the professions: accountants, architects, engineers, quantity surveyors and lawyers, of course. So that's what brings about efficiency as well. But also, when like the way we are setting up the International Arbitration Center, we'll have the expertise from across the world. Our panel of arbitrators will be from across the SADC region. So it means that you can have expertise, well-experienced arbitrators to resolve the dispute. So that's how it comes about to bring about more efficiency. But also, on the panel of arbitrators, there will be obviously more arbitrators to choose from compared with. So, for example, at the moment, if you go to because these are matters of commerce, at the moment we have 6 judges at the High Court Commercial Division, handling almost 2,500 cases, and that's a lot of work. But if parties go for arbitration, they will be able to choose arbitrators who perhaps will be more free, and their disputes can be resolved quickly, because the business community wants to get things moving quickly, differences resolved. Because you remember, a dispute is not really it's not their business. Let's say you are in telecommunications, your business is telecommunications, but differences can arise in that business. You want to resolve them quickly and carry on with it's like a diversion. So if you take a diversion, you don't want to remain on the diversion forever. You want to get on the diversion and go back into the main. Yeah. So that's the advantage that the efficiency of arbitration can bring, but it comes at a cost.
Mm-hmm. Now, since you've mentioned that each case carries its own significances and the type of people the type of parties to be involved.
Yeah.
Now, in your opinion, which is an affordable route, and how do you balance cost implication and efficiency there?
If you take, for example, the filing fees in the court, obviously it will be cheaper to file in the court. But I've just given you an example at the moment. If you file your case within the commercial court today, there are 6 judges. They already have a huge backlog of cases to resolve. There are other challenges that they're dealing with. We know that there are other constraints that they have to deal with. So arbitration worldwide tends to be more efficient, so the business community finds it cost efficient. It might be costly, but it is worth the cost. Yeah.
Okay. So, as we know, court matters have the avenue of the right to appeal.
Yes.
Is that so?
Correct.
Now, does arbitration provide this, and to what extent?
So the regime of arbitration that we are setting up under the Malawi International Arbitration Center, we are operating a regional framework. In April, I was in South Africa even with the Minister of Justice to inform the SADC community and the world what stages we had reached in Malawi as of April. So one of the major things that we did in South Africa was to sign an alliance charter for the 12 SADC countries. All the law societies signed that charter. We are working on setting up a regional arbitration center where it will have an internal appellate mechanism, but within the arbitration framework. So our colleagues in South Africa, the Arbitration Foundation of Southern Africa, already has got the framework. So we are adopting that framework, and we will use it here as well. We will not work in isolation, because this is international arbitration. Mm-hmm. Yeah.
Now, if an arbitrator's decision is final,
yes,
and it's binding, how are the rights of a party not satisfied with the arbitrator's decision taken care of, as against the principle of quick and efficient disposal of matters in an arbitration?
In any dispute resolution, someone is bound to be unhappy about the outcome, right? That's normal. Even if you go to court, somebody wins, somebody loses. So what the law has done, and the law is at the highest level, the Constitution in section 13L of the Constitution has actually said, let's adopt measures that will promote alternative dispute resolution, including arbitration, conciliation, and even negotiation, because the law appreciates that the courts can be crowded. So the person who is not satisfied with the outcome of an arbitral award, there will be mechanisms within the review mechanisms. They are there, but there are limited circumstances in which you can do the review. Otherwise, you must understand that by the time you are going for arbitration, the foundation of any arbitration is agreement. You will have agreed that our differences will resolve them by arbitration, and this is the standard that is accepted, and so we're bound to accept the decisions of arbitral tribunals.
Now, you personally have been a practicing lawyer for years.
Yes, yes.
And now you are the president of Malawi Law Society.
I'm also the chairman of the Malawi International Arbitration Center.
Yes.
Yes.
Now, those are three positions that are putting you in, let's say, a war position key to know what's lagging behind and what's moving forward. Most of the citizens have been complaining about the backlog of cases and delay in judgment.
Yes.
Is that correct?
Yes, very correct.
Now, how will the referral of matters to arbitration through MAIC help deliver a system of the justice here in the country?
The reference of matters to the Malawi International Arbitration Center will help to reduce the workload that already there is, because it will be commercial matters, and I said at the beginning that as we speak now, if you look at the report that the judiciary delivered for last year, with 6 judges at the commercial court and with a backlog of about 2,300, 2,500 cases, the disposal rate for cases in the commercial court is at 38%. Meaning, if you put your case into the justice system at the commercial court, you have 62% chance of not getting your decision within the year, because the judges are crowded, they have a lot of work. So what the establishment of the arbitration center will do is to give an alternative route where, if parties have agreed, they will have a proper institutionalized framework where they can say, we will go this route, and there will be better choices there, because then they can choose the arbitrators depending on the subject matter in issue. You can have the relevant expertise. So, and there'll be a bigger panel. I think it will not be six arbitrators. It will be much longer, because there are many people who will be interested to be arbitrators, and we will be trained. We'll be exploiting our colleagues in the international community to be part of the panel. So I think it will provide an alternative.
Now, in view of this foregoing to what you have just explained,
yes,
what binds the ruling of MAIC?
So the foundation of any arbitration is agreement, okay? And once you agree that we will go, usually the business community, when it is entering into the contracts, they will usually say, our differences, if suppose this contract brings about differences, how are we going to resolve them? We'll go through arbitration. If in those agreements they mention that no, these will be resolved at Malawi International Arbitration Center, then when you go there, the parties are bound by the decision that the arbitrators make at the center. Yeah.
Now, does arbitration only apply to commercial cases? Not necessarily. Labor matters employment matters can be dealt with there. The key is agreement. If you agree that we will resolve your dispute by arbitration, it can be resolved by arbitration. But mostly, in practice, these kind of agreements usually appear in commercial matters. So the practice has emerged that this mostly is about commercial investment matters. But if you agree that we will resolve our differences by arbitration, even in an employment setup,
you can get a resolution by arbitration.
Mm-hmm. Now, as you've mentioned, disputes arise, matters arise when two people agree or disagree. Mm-hmm. Now, what should the business community expect from MAIC?
So for the business community in Malawi, I think this is an opportunity that they can take part in resolving, providing a solution to one of the challenges that the businesses in Malawi face about the challenges and the delays in the courts. Our courts, they do their best, but they have limited. There are several constraints. So this is an opportunity where the law has allowed to say, if you agree, we will not interfere with your agreement. There is actually a Supreme Court decision that has said that recently, saying if you agree that you will resolve your difference by arbitration, we will allow you to go there. We will not interfere. So the establishment of the Malawi International Arbitration Center is actually an opportunity for the business community to come in and to support it and to make sure that the center kicks off on the ground. Yes.
Now, speaking of kicking off on the ground, when should we see the first case in action?
Right now, after the symposium that we had on 5 and 6 September, we are expecting that, because at the moment that symposium was just about to recruit members. So we are expecting that by 5 October we will be done with the recruitments. Then I think within October, November, we will have our first meeting with all the stakeholders that will have joined the center. And then from there, we will know maybe by the end of December, but I'm sure that early next year, the center will be up and running. Mm-hmm. Yes.
Now, in this whole project of MAIC, and in this whole business of MAIC, what's in it for the government?
Well, the government, this is a private sector-led initiative. The role of the government basically is to facilitate the creation of the relevant legal framework. So for the government, obviously, it can't be a party to this, because this is a private sector led, and what it can do for the country, and I think maybe I can say for the government in that regard, what it can do for the country is that it would make the country a good destination for foreign direct investment. The investors will look and say, they'll have confidence. And if they have confidence in our dispute resolution mechanism, then they can bring in foreign currency, they can bring in easily investments easily into the country. And so that will be the broader purpose. And that's why I think that the government has also been supporting our request that help us here. We need the legal framework here. But there is not going to be direct benefit, as it were, to the government, say, because it's a private sector led, the legal framework creates for the private sector to sort out their differences. But what it means is that even the courts will be less burdened with some of the work which would otherwise go to the courts. So as a branch of government, maybe that's the benefit, things like those. Yeah.
Now, on 14th March 2024,
yes,
the court delivered a judgment application which complied of competence versus competence on a case involving anti-arbitration injunction at the High Court, and the Supreme Court refused to grant that injunction.
Yes.
Now, as a practicing lawyer and one who is on the forefront with arbitration, what does this mean to the justice system of Malawi?
Okay, so that judgment was delivered by Justice of Appeal Kapanda. He basically was dealing with a case where two parties had an agreement to do with the construction of the railway line in Malawi, and they had agreed in that agreement that they will resolve their differences by arbitration in London. And so when a dispute arose, the other party was trying to referring the matter to arbitration in London. And then the other party was saying, no, I think it's expensive, it's too far, and all the like. So the High Court said, no, we can't stop you from going to arbitration, go for arbitration. and then the matter went to the Supreme Court. So on 14th of March, the Supreme Court confirmed the competence principle, basically to say that if you agree for arbitration, we, the courts, will not intervene in the issue. The arbitral tribunal must be a place where all issues to do with your dispute are resolved. We can't be having part of the problems here, part of the problems in the courts, and part of the problems in the arbitral center. Go to the court. The arbitral center must be a one-stop shop for everything to do with your disputes. So basically, the court said, so when the parties have agreed for arbitration, we, the courts, will not take jurisdiction on the matter. Jurisdiction is left to the arbitral center. So basically, it's a very significant judgment because it now confirms the point that we will now, if we have a center here in Malawi, it means that instead of like this going to London, they can refer the dispute locally. It means that you are controlling even the foreign currency and like instead of exporting your dispute, you are now resolving it locally. So it's a very good judgment. It settles a very important principle that is accepted within the arbitration world, that when you agree, we will let you go resolve your dispute in the way that you have agreed. So that's the significance of that judgment.
Now,
yes.
with the reference to what you have just said,
Yeah.
have we seen much of brain drainage in this area?
That disputes being exported to
yes,
a lot because we don't have the center in the country. So there are already well established arbitration centers in Singapore so it's quite expensive just even traveling alone. And so I think that that has been a heavy cost even within the SADC region. At least in 1996, they established the Arbitration Foundation in Southern Africa, which we are working with, control some of the exportation of disputes, quite significant volumes of money that has gone out of the SADC region, that has gone out of the country because we don't have these kind of centers locally. But the SADC region, the Malawi Law Society, the Malawi Chamber of Commerce, we're now working to say, no, let's have this center in our country. Mm-hmm.
Now, since there's the urge to say let's have this center in our country, we have seen Justice Razine Mzikambanda, SC, the Attorney General himself and the President himself advocating that come to Malawi, this is a powerful way of investment. Now, in view of that light, we have seen Malawi Law Society training almost 200 lawyers here in Malawi, from Zambia, Malawi, Zimbabwe, South Africa. You train them right here in Malawi, in line with arbitration. What does this mean to the judicial system, the law society, and Malawi as a whole?
So once the government signed up to the New York Convention, we saw that as an opportunity, and then we started conducting the trainings so that when we are setting up this center, we have local expertise. Even actually right now we have about 26 lawyers that will undergo some training next week on the same, so that by the time we are setting up, there is local competence as well, because we also need to build capacity in Malawi. So that's what it means, and the support from the government is very helpful.
Now, as we approach the end of the program Unpacked, the lawyers and the general public, they have been on the forefront for judicial independence. Now, how will MAIC be as far as judicial independence is concerned?
Well, this is a private sector-led initiative, and so the independence is guaranteed, because if the arbitrators and the are not operating independently, then there is also issue of competition there. I don't think they will be able to get more assignments if the arbitrators look like they are not competent or independent. So I think it's very important, but also we are going to be working with well-established institutions already in the SADC region. Right now, we are discussing with the Arbitration Foundation of South Africa. We are discussing with the Permanent Court of Arbitration. So these are already experienced institutions that are also going to provide a lot of technical support, so that it's very professional. It's an international standard that we are trying to apply, and I'm sure that we will maintain it. If we don't maintain the standard, then we will not be competent to compete on the world scale.
Now, your last word to the public and the investors out there, what can you say about arbitration in Malawi?
The legal framework is set up. The business community must come and join, be partners in the Malawi International Arbitration Center, so that we can together set up a robust and institutionalize an alternative framework for resolving commercial and investment disputes for the good of our investment environment in Malawi.
For the good of the investment environment here in Malawi. Mr. Mpaka, we would like to thank you here on Unpacked for making time to engage with us.
I also thank you very much for having me.
Thank you. Yeah. That's all we had in today's program of Unpacked. I was talking to Mr. Patrick Mpaka, who is the president of Malawi Law Society, and he's also one of the custodians on the forefront for the Malawi International Arbitration Center, which was recently introduced here in Malawi. Now, the good thing about arbitration is that it is going to open up doors for Malawi, and it's going to open up more engagements internationally. My name is Ghwabupi Mwabungulu. Until next time, I say keep watching Unpacked, and goodbye.